S-Chan presents educational video lectures as per the new UGC curriculum. Difficult concepts made easy. Study anywhere, anytime.
इतना तो बहुत क्लियर है कि आजकल ट्रांजैक्शंस ऑनलाइन पेमेंट्स और चेक्स के थ्रू बहुत कॉमन है एंड दैट इज़ वेरी रैम्पेंट स्पेशली इन द कॉमर्स. नाउ जब कोई कंपनी अगर किसी ट्रांजैक्शन में एंटर करती है और फॉर दैट मैटर एक बिजनेस पर्सन एक ट्रांजैक्शन में एंटर करता है एंड द पेमेंट इज मेड थ्रू चेक, व्हाट इज द पॉसिबिलिटी दैट एवरी टाइम द पेमेंट विल बी रिसीव्ड इनटू द अकाउंट? ऐसा भी तो हो सकता है कि किसी ने चेक तो ड्रॉ कर दिया है पर उसका इंटेंशन नहीं है पे करने का. ये कब पॉसिबल हो सकता है? इट कैन बी स्पेशली इन द केस जब जिस पर्सन ने चेक ड्रॉ करा है उसके बैंक में सफिशिएंट फंड्स ही नहीं है. अगर उसके अकाउंट में सफिशिएंट फंड्स नहीं है तो ऑब्वियसली ड्रॉई बैंक पेमेंट नहीं करेगा. उसके अकाउंट में से डिडक्शन होने के लिए पैसे ही नहीं है तो जिसको पेमेंट करनी है उसके अकाउंट में पेमेंट जाएगी ही नहीं. अगर ये सिचुएशन बहुत कॉमन हो जाए तो इसका इम्पैक्ट कॉमर्स पर डेफिनेटली पड़ेगा. डे टू डे बिजनेस, डे टू डे ट्रांजैक्शंस इससे बहुत ज़्यादा इम्पैक्ट होंगे एंड पीपल विल स्टॉप प्रेफरिंग चेक्स एज अ मोड ऑफ पेमेंट. दे वुड रादर स्टार्ट रिलाइंग ऑन व्हाट इज एसेंशियली द कैश ट्रांजैक्शन. बट कैश ट्रांजैक्शंस के खुद के कुछ ड्रॉबैक्स हैं, जैसे इंक्रीज इन ब्लैक मनी इन द मार्केट. देयर इज अ वेरी लेस लेवल ऑफ रेगुलेशन इन द कैश मार्केट एंड द गवर्नमेंट tries to make sure that the transactions are done via those means wherein they can track down the transactions. That is, they're done through the mechanism of banks.
If you want to study this topic in detail, refer to the book by S-Chan Publishing and Vikas Publishing House. Link is provided in the description box.
Students, I am Kanika Kaushik and I welcome you to S-Chan Academy where we will be discussing dishonor of checks in this video. So topic for today is dishonor of checks. So firstly, what is a dishonor of check? A dishonor of check is when the bank refuses to honor the check. That is, the bank refuses to make the payment to the payee. If you recollect what all we discussed in the different types of negotiable instruments in one of our previous lectures, we discussed three types: promissory note, bill of exchange and check. Now, if you recollect, we tried to understand how there are three parties involved in a bill of exchange and one in a promissory note, and the third party involved in a check is essentially a drawee bank. Now what happens? Who is supposed to make a payment? In the case of a promissory note, it is supposed to be the maker of the promissory note. In the case of a bill of exchange, it is essentially the acceptor of the bill of exchange, and in the case of a check, it is the drawee bank. Now if we try to understand what is dishonor, we would be trying to look at it by breaking down the word. So if you read the word dishonor, you can say that it comprises of two different words, dis and honor. So dis is essentially a prefix which means the negative of the word. So if it is dishonor, that means it is the negative of honor, that is the opposite of honor. So here what is happening? The person who is supposed to honor the negotiable instrument is not honoring it, and that is what is called the dishonor of a negotiable instrument. So now dishonor is of two kinds. One is by non-acceptance and the second one is by non-payment. So non-acceptance and non-payment are given under the Negotiable Instrument Act under different sections, and we'll be discussing them in detail now. So dishonor by non-acceptance. So this type of dishonor is possible only in the case of a bill of exchange. Can you answer why? Well, because non-acceptance is possible only in a bill of exchange. In a promissory note, there is no question of an acceptance because only two parties are involved, the maker and the payee. In the case of a check, the third party is essentially a drawee bank, and the drawee bank is not supposed to make an acceptance. So here, acceptance is supposed to be made only in the case of bill of exchange, and this type of dishonor will operate only in the case of a bill of exchange. Now this can happen in the following circumstances. The first one is when the drawee refuses to accept the bill of exchange. So in a case, say a person A has drawn a bill of exchange and that has been given to person B for acceptance, and person B is not accepting it, then that will be a dishonor by non-acceptance. Now drawee is incompetent to contract. So one of the essentials of a valid bill of exchange is that the parties to the bill of exchange, they are competent to contract. So if in this case, if the drawee is incompetent to contract, he can be a minor, he can be an insolvent, he can be a person of unsound mind. In these cases, the person will be incompetent to contract. And if he is incompetent to contract, in that case, dishonor by non-acceptance would be possible. Now the drawee cannot be found in cases where presentment is excused. So there may be a case wherein the negotiable instrument, that is the bill of exchange here, does not require presentment of the instrument to the drawee. Now in that case, what will happen? The drawee cannot be found because at first the presentment is not required, and when the person is seeking a payment, the drawee cannot be found. So in that case, what is happening? It is a dishonor by non-acceptance. Now the drawee makes a qualified acceptance. So if you recollect the different types of negotiable instruments we discussed the various essential elements of a bill of exchange in detail. And one of the most important essential ingredient was the fact that the acceptance should be unqualified. So if it is a qualified acceptance, it is not a valid bill of exchange here. Now the dishonor by non-acceptance. If you look at what is the text of the section under the NI Act, it is basically what all we have discussed just now. So it states a bill of exchange is said to be dishonored. So look at here, it is stating only bill of exchange. So this type of dishonor can only happen in the case of a bill of exchange. Is said to be dishonored by non-acceptance when the drawee or one of several drawees not being partners makes default in acceptance upon being duly required to accept the bill, or where the presentment is excused and the bill is not accepted. Where the drawee is incompetent to contract or the acceptance is qualified, the bill may be treated as dishonored. So here one thing we have not discussed in the previous slide, and that is non-acceptance by one of several drawees not being partners. So if there is a non-acceptance by one of the several drawees, a bill of exchange may mention 2-3 drawees or more than that for that matter. So if even one of them does not accept the bill of exchange, then that will be a dishonor by non-acceptance. But here again an exception is there. If there is one of several drawees and he is not accepting and the acceptance is given by other person and they are partners, in that case dishonor by non-acceptance will not operate. Now let us come to the next type of dishonor, which is dishonor by non-payment. So as the term is very clear, it is dishonor, that means the payment has not been made, the person who was supposed to make the payment has refused to make the payment. And how? It is by non-payment, that means the payment has not been made. The question of acceptance does not come here. So dishonor by non-payment happens when the maker of the promissory note, acceptor of the bill of exchange, or the drawee of the cheque defaults in the payment when duly required to do so. So what is happening? Who can default in this case? In the case of a promissory note, it will be the maker. In the case of the bill of exchange, it will be the acceptor. And in the case of a cheque, it will be a drawee. So if we look at the text of the section 92 discusses what is dishonor by non-payment, and it states that a promissory note, bill of exchange or cheque is said to be dishonored by non-payment when the maker of the note, acceptor of the bill of exchange or drawee of the cheque makes default in payment upon being duly required to pay the same. It is nothing different, it is only a more technical or a more formal language that has been used in the text, and this is the same which has been discussed in the previous slide. So students, as of now we have discussed what is dishonor, how is an instrument dishonored, what is a dishonor in the case of a bill of exchange, what is a dishonor in the case of a promissory note and a cheque. How are these types of dishonor operating? That is, how is a bill of exchange dishonored by non-acceptance, and how are these three instruments dishonored by non-payment? So here we will be stopping for a short break and we'll come back and discuss the different types of dishonor and the legal provisions after the break.
Now quality learning is easily available at your doorstep. Chand Academy brings detailed lectures based on UGC curriculum as per the New Education Policy 2020. So do not forget to subscribe to the Chand Academy and access the wide world of knowledge conveniently sitting within the comfort of your home. Stay connected and keep watching Chand Academy. Happy learning!
Hello students, welcome back to Chand Academy, and in this lecture we are discussing the dishonor of negotiable instruments and checks in particular. So before going on a break, we discussed what is the meaning of dishonor, how is a negotiable instrument dishonored, that is the two types of dishonor, which is by non-acceptance and the second one is by non-payment. We also discussed the legal provisions, that is the sections which are given under the Negotiable Instrument Act, which cover non-acceptance and non-payment as modes of dishonor. So now we will be continuing with our discussion and we will discuss what is notice of dishonor. So it essentially states that a notice of dishonor has to be given. So if a negotiable instrument was dishonored, that does not mean you will sit on that instrument or when you feel like you'll just go to the court and ask for a remedy from the court. No. If there is a dishonor, you have to give a notice of the same to whom? Well, let's see in this section. So it states by and to whom notice should be given. So when a promissory note, bill of exchange or check is dishonored by non-acceptance or non-payment. So here again, dishonor can either be by non-acceptance or by non-payment, and in both the cases you are supposed to give a notice of the same. The holder thereof or some party thereto who remains liable thereon must give notice that the instrument has been so dishonored to all other parties whom the holder seeks to make severally liable thereon, and to someone of several parties whom he seeks to make jointly liable thereon. So now here what is he saying? The text of the section is saying that you have to give a notice, and who you are supposed to give the notice to? Well, if you want to hold certain people severally liable, that is they will be having a different liability of each, then in that case you would be giving the notice to every single one of them. So different notices will go to every single one of them whom you want to make severally liable. So if there is several liability, you have to give a notice to each and every person amongst them. But if you want to hold someone jointly liable, in that case what is happening? Say for example, if you have persons A, B and C and you want to hold them jointly liable. So what is happening? If you want to hold them jointly liable, a notice to even a single one of them will suffice. That means if you give a notice to A and you don't give a notice to B and C, that means it will be a valid notice. But if you want to hold them severally liable, what will happen? You have to give a notice to every single one of them. I hope this is clear that when there is a joint liability intended, then in that case a notice to one amongst the many is sufficient. But in the case wherein you want to hold them severally liable, several liability means a different liability for everybody. They don't have a joint liability. In that case, a notice has to be given to every single person amongst them. Now, what it also states is that nothing in this section renders it necessary to give notice to the maker of the dishonored promissory note or the drawee or acceptor of the dishonored bill of exchange or check. So what is he saying? If he is saying here that to all other parties, he is not making it mandatory to give it to all the other parties. What is mandatory here? That you have to give the notice to every single one of the persons which you want to make liable. But if you do not give a notice to any amongst them, that essentially implies that you don't want to make them liable. And just because you have not given a notice, that does not mean your notice will be invalid. So this section is not making it necessary to give notice to the maker of the dishonored promissory note or the drawee or acceptor of the dishonored bill of exchange or check. So now what is the mode of notice? Section 94 is a pretty lengthy section, and I believe that just these points are mentioned there and we'll be discussing them so that we are covering the entire length and breadth of the section 94. It states that the notice may be oral, written, partly oral and partly written. So that means that you can either tell to the person by your word of mouth that your instrument has been dishonored, you can give it to in writing, or it can be partly oral and partly written, so that you can say something by words and you can also supplement that by something written or supplement your written statement by something oral that you add later on. Now, what is the mode of notice? Who are you actually supposed to give the notice to? So, you will be giving it to the person himself, or it can be to his duly authorized agent. This is possible when the person has appointed an agent in this regard. Secondly, it can be to a legal representative. So in what case does a legal representative come in? It happens when the person has been declared dead. So this happens when the person to whom the notice was supposed to be made has died. So in that case, the notice to the legal representative will suffice. Now in the case where this person has been declared an insolvent, so what happens? An assignee has been appointed by the court. So if the person has been declared insolvent, it is sufficient that you give the notice to his assignee. Now it cannot happen, see, if you have a check, the check has been dishonored, you're sleeping on that check for the next 3 years, and after 3 years you wake up that, oh, I had a check that was dishonored and now I will give a notice. No, that is not possible. You have to give a notice within a reasonable time after the dishonor. Now the law does not define what is the reasonable time, but then again, reasonability of time is basically gauged from the fact that what is the common practice in that particular business. And as of now, when we have fast modes of communication, so this notice should be given as quickly as possible. Now where would you send this notice? If it is oral, तो बहुत क्लियर है कि आप उस पर्सन को डायरेक्टली नोटिस दे रहे हैं, आप उसके साथ डायरेक्टली कम्युनिकेट कर रहे हैं, तो प्लेस का कोई क्वेश्चन नहीं उठता है. So it does not say that you have to be at a particular place to give that oral notice. No. But if you are giving a written notice and you're sending it by post, so where are you supposed to send that notice? So you have to send it at the place of business. This will be your first priority. If the person has a place of business, you will be sending the notice here. But for example, if the person does not have a place of business, it is then that you would be sending the notice to his residence. So remember that the first priority will always be the place of business, and if the place of business is not there for that person, only then you will be sending the notice to the residence of the person. So now we will be discussing what the section 138 of the NI Act, which is the Negotiable Instrument Act, has to say about it. देखो, what happens is, अगर एक civil transaction है, यानी कि कुछ commerce related, कोई business related, contract related transaction है, तो उसको हम एक civil transaction बोलते हैं. And civil transaction is not considered an offence per se. But अगर dishonor of instruments की बात करी जाए, तो especially dishonor of cheque, किसी certain circumstances में अगर वो situation qualify करती है, तो उसको एक offence बनाया गया है. And offence is something criminal in nature. That means उसमें punishment will be in terms of not compensation and damages जो हम एक civil law में पढ़ते हैं. The punishment will be in terms of either fine or imprisonment. So now let us read the text of the section. Any check drawn by a person on an account maintained by him with a banker for payment of any amount of money to another person from out of that account for the discharge in whole or in part of any debt or other liability is returned by the bank unpaid, either because of the amount of money standing to the credit of that person is insufficient to honor the check, or that it exceeds the amount arranged to be paid from that account by an agreement made with that bank. So we'll just stop here and we'll discuss this particular portion first and then move ahead. So what is it saying? That a check has been drawn by a person on the account that he is maintaining with the bank. Say for example, if there is a person A and he has an account with SBI and वो एक चेक ड्रॉ कर रहा है जहाँ पे SBI के अंदर उसका अकाउंट है और उस अकाउंट से उसने किसी थर्ड पर्सन को पेमेंट करनी है. So first thing is there should be a check and it should be drawn on the account he is maintaining with the banker. Secondly, कुछ पर्पस होना चाहिए उस चेक के लिए. That is, it should be either for the payment of any debt or other liability. इसमें debt or other liability holds a lot of significance. That is returned by the bank unpaid. अब उसके रीजन क्या हो सकते हैं? Firstly, the funds were insufficient, or the funds or the amount which are supposed to be paid, it exceeds the amount arranged to be paid from that account by an agreement made with that bank. Say for example, अब हम ना इनके examples लेते हैं धीरे-धीरे and we'll try to discuss it in detail. Now, when I say any debt or other liability, this is an essential ingredient. This essentially implies the fact कि अगर कोई check, say for example, if your father gives a check to you for your birthday and that check bounces, there is an insufficiency of funds in your father's bank account. Can you go to the court for that? No, because that is a gratuitous gift given to you by your father. But if it was for the payment of any debt or other liability, it is only then that section 138 will operate. तो जहाँ पे कुछ पेमेंट एक लीगल लाइबिलिटी नहीं है, कोई डेट नहीं है, उस केस में आप सेक्शन 138 को अप्लाई नहीं कर सकते. सेकेंडली, या तो फंड्स इनसफिशिएंट होने चाहिए. दैट मीन्स अगर आपने से फॉर एग्जांपल 1 लाख रुपीस का चेक इशू करा है बट आपके अकाउंट में सिर्फ 50,000 है, उस केस में डेफिनेटली बैंक विल नॉट बी ऑनरिंग द चेक, राइट, बिकॉज योर अकाउंट डज नॉट हैव सफिशिएंट फंड्स. सो व्हाट विल हैपन? Firstly, here insufficient funds are there, and if there is any debt or liability, in that case section 138 will apply. The second thing can be, जब आप see what happens, banks have different types of bank accounts, different types of saving accounts. So probably जिस कैटेगरी का आपका सेविंग अकाउंट है उसमें एक पर्टिकुलर लिमिट स्टिपुलेटेड है कि आप सिर्फ से फॉर एग्जांपल 2 लाख रुपीस की पेमेंट कर सकते हैं बाय चेक, बट यू ड्रॉ अ चेक दैट इज से टू द ट्यून ऑफ 5 lakh rupees. So what is happening? This amount is in excess of the agreement you have with the bank, right? जब आपने एक सेविंग्स बैंक अकाउंट खोला, आपने टर्म्स एंड कंडीशंस में उसमें डेफिनेटली मेंशन्ड होता है कि आप कितनी पेमेंट कर सकते हैं. अगर आप उसके बियॉन्ड पेमेंट कर रहे हैं, that means it is exceeding the amount arranged to be paid. So is this clear? I hope it is clear that whenever there is a check that has been drawn, it is for the payment of any debt or liability and the funds are insufficient or exceed the amount arranged to be paid. So now what is happening? Such person shall be deemed to have committed an offence and shall, without prejudice to any other provision of this act, be punished with imprisonment for a term which may extend to 2 years. यानी कि उसको 2 साल तक की जेल हो सकती है, और फाइन कितना होगा? मैक्सिमम वुड बी ट्वाइस द अमाउंट. से फॉर एग्जाम्पल आपने 1 लाख रुपीस का चेक इशू करा जो बाउंस हो गया, जिसको डिसऑनर कर दिया बैंक ने, तो आप पे फाइन कितना लग सकता है? अप टू रुपीज 2 lakhs. Now there are certain exceptions given under section 138. These exceptions are firstly when the check has been presented to the bank within a period of 6 months, that is it is timely presentment of the check or within the period of its validity. तो जब तक चेक वैलिड है आप तब तक उसको प्रेजेंट कर रहे हो या within 6 months प्रेजेंट कर रहे हो, whichever is earlier. Now the payee or the holder in due course of the check, as the case may be, makes a demand for the payment of the said amount of money by giving a notice in writing to the drawer of the check within 30 days of the receipt of the information by him from the bank regarding the return of the check as unpaid. यानी कि आपको 30 days का आपको नोटिस देना है within 30 days. The drawer of such check fails to make the payment of the said amount of money to the payee or as the case may be to the holder in due course of the check within 15 days of the receipt of the said notice. So now what is happening? For the purpose of this section, debt or other liability means a legally enforceable debt or other liability. So what is happening? आपको पहले notice देना है within 30 days of dishonor. जब ये lapse कर जाएगा, आपने within this period you have to give a notice for dishonor, right? And after you've given the notice, you will be waiting for how much time? You'll be waiting for 15 days. Now, the drawer of such check fails to make the payment of the said amount of money to the payee or as the case may be to the holder. यानी कि अगर 15 days में the drawer is failing to make the payment, in that case you can go ahead by proceeding for the you can go ahead by filing a case under section 138 of the Negotiable Instruments Act. Let us just quickly look for the essentials of an action under section 138. यानी किन किन केसेस में हम सेक्शन 138 के अंडर एक्शन ले सकते हैं. The first one, there is a dishonor of check. Secondly, payment is in discharge of a debtor liability, यानी कि आपका कोई debt है या आपकी कोई और legal liability है. Presentment of check within the period of its validity, आपने उसकी validity के अंदर check को present करा है. The check was dishonored due to insufficient fund, insufficiency थी fund में, and there is a notice given to the drawer. And after the notice that has been given to the drawer, he still fails to pay the amount. Now, what are the circumstances under which a banker is justified in dishonoring a check? So, payment countermanded by the drawer. So, say for example, if I made a check and I instruct my bank to stop a payment, there might be a possibility कि मैंने किसी transaction में enter करा एक person के साथ, that person was supposed to sell me some goods, और मैंने चेक तो इशू कर दिया बट मेरे पास गुड्स आए ही नहीं, तो उस केस में मैं अपने बैंक को डायरेक्ट कर सकती हूँ, उसको इंस्ट्रक्शंस दे सकती हूँ कि आप पेमेंट स्टॉप कर दीजिए, आपको पेमेंट नहीं करनी है इस चेक के अगेंस्ट। सेकेंडली, अगर ड्रॉअर की डेथ हो गई है, यानी जिस पर्सन ने चेक बनाया है उस पर्सन की डेथ हो गई है एंड द सेम हैज कम टू द नॉलेज ऑफ द बैंक, इन दैट केस एज वेल बैंक पेमेंट को रोक सकता है। नाउ द नोटिस ऑफ कस्टमर्स इंसॉल्वेंसी, नाउ इन दिस केस व्हाट इज हैपनिंग, जिसको पेमेंट करनी है यानी जो हमारा पेई है, जो कस्टमर है, वो इंसॉल्वेंट हो गया है, उस केस में भी बैंक अगर उसको नॉलेज है कि वो इंसॉल्वेंट हो गया है, पेमेंट रोक सकता है। एंड देन लिक्विडेशन ऑफ अ कंपनी, अगर किसी कंपनी ने चेक इशू करा है और वो कंपनी लिक्विडेशन प्रोसेस में जा रही है, तब भी बैंक के पास एक ऑप्शन है जहां पे वो चेक को डिसऑनर करे और उसके ऊपर कोई लायबिलिटी नहीं होगी। सो स्टूडेंट्स, in this lecture we discussed what is dishonor of a negotiable instrument, and we discussed dishonor of a check in detail. We discussed how dishonor of a check can become a criminal offence in certain cases, and we discussed the various essential ingredients which will lead to an action under section 138 of the Negotiable Instruments Act. Thank you.
If you want to study this topic in detail, refer to the book by S. Chand Publishing and Vikas Publishing House. Link is provided in the description box. If you found our video interesting, please like, share and subscribe. And do not forget to press the bell icon.
All rights reserved. This video has been prepared for educational purposes only. No part of it may be reproduced or copied without the permission of the copyright holder.